There's a quiet section buried inside Ghana's Labour Act. Most workers have never read it. It is section 66. What it states is very surprising. The entire part 8 of the Labour Act, the portion that protects workers from unfair dismissal and guarantees redundancy pay, does not apply to you if you're on a fixed-term contract, a probationer, or a casual worker. This rule was recently applied by the Supreme Court of Ghana, and all courts follow the Supreme Court on points of law. So when the Supreme Court speaks, we must pay attention. John was a Tanzanian-born Canadian expatriate. In 2009, he signed a 2-year contract as marketing and development manager for Red Sea Company. The contract promised a gratuity in line with labor laws if he was terminated early. 8 months into his contract, he was informed that due to global economic downturn and the lack of projects, his services were no longer required. After negotiations, they agreed that he was owed $39,595. Then they deducted $2,700, claiming that he had lost some company funds. Before this was paid, however, the company was smart. They put 2 documents in front of him to sign. They were waivers and releases. He was to sign, and once he did, he would forever give up any further claims against the company. He would take the money and keep quiet forever. John signed it. 10 months later, as you might suspect, John sued Red Sea at the High Court. He claimed unfair termination and he demanded redundancy pay. He further argued that he signed the waivers under duress, and he even sued for libel because his name and photograph appeared in the Daily Graphic after he was removed. The High Court dismissed the libel claim because there was no bad intention found. But it started with John on the termination, ordering 12 months' salary and other payments, directing the parties to negotiate redundancy pay. John was winning, and then Red Sea appealed and won on a technicality. The Court of Appeal ruled that the High Court had no jurisdiction to hear the unfair termination matters at all. The case then went all the way to the Supreme Court. For a long time, the law had said that unfair termination and redundancy disputes belonged exclusively to the National Labour Commission, the NLC, and not the courts. Employees who went straight to the High Court were turned away at the door. The Supreme Court stated that now that had changed. It reasoned that unfair termination isn't just a labor dispute, but at its core, it's a human rights issue rooted in the Constitution, and the High Court had full jurisdiction over such constitutional rights. So now you can take unfair termination matters to the High Court or to the NLC. Both doors are open. John must have felt a flicker of hope, but he still lost completely, but for different reasons. First, under cross-examination, John admitted that he signed the waivers voluntarily, and there was no real pressure on him. There was no duress. Second, those waivers were binding and they were clear. They created a conclusive presumption that he intended to release Red Sea from any claims. Finally, and the most fatal, John was on a fixed-term contract. Section 66 applied. The protections in Part 8 of the Labour Act on unfair termination and redundancy never applied to him. He had been fighting a battle that was already lost before he started. What do we learn from this case? If you are a contract worker, a probationer, or a casual worker, Section 66 has already stripped you of the Labour Act's core protections. You are not on the same footing as permanent staff. That is your legal reality. But perhaps a collective bargaining agreement properly drafted will be your shield. Second, a signed waiver is very difficult to undo. Courts will hold you to your signature, and if you sign away your rights, you cannot be heard to complain thereafter. Follow Superlaw GH Studios for more. Real stories, real cases, real people.